Hello, everybody.
You call next case. Give me 1 second, please.
Yes, Your Honor.
All right. Next case, State of Ohio versus Nakia Gray. I pronounced that correctly? Nakia?
Yeah.
25 CR 1410. Ms. Smith, I'll hear from you at first.
Thank you, Your Honor. On behalf of Ms. Gray, Ms. Gray is in receipt of her indictment. She's had it for more than 24 hours and waives any defects in time, manner, or place of service. She further waives reading of the indictment and advisement as to penalties, respectfully enters a plea of not guilty, and asks to be heard on bond.
Thank you. So, Ms. Gray, you received a copy of the indictment?
Yes.
When did you get that, if you remember?
I got it this past Wednesday.
Okay, so a couple days ago at least?
Yes.
Okay. You do have the right to have me read it to you, as I briefly just explained to the other gentleman, but you can also waive that. Would you like me to read it to you at this time, or do you want to waive that?
Waive it.
All right. Then in regards to each of the 4 counts in your indictment, what is your plea to each of those 4 counts?
Not guilty.
I'll enter a plea of not guilty. As to bond, let me hear from the state first as to what they're seeking here. Mr. Shapiro?
Your Honor, thank you, Your Honor. I have had a conversation with Ms. Smith, also the victim in this matter. These charges stem from a relationship that the defendant has with her son's father. The defendant has a 3-year-old child with a man named James Moss. He's the victim in this case. The bond was set at the municipal court at $50,000 cash surety with conditions of no contact with the victim or Bishop Park Apartments in GPS. The bind-over charges are more serious than what was actually indicted. The bind-over was a menacing by stalking against Mr. Moss, also a trespass and a habitation.
Against Mr.
Mr. Moss being the victim.
Oh, not against him, but I mean, all right.
He's the victim.
Gotcha.
And the F4 trespass and habitation also was his apartment. Turns out the indictment's a lot different here. We have a criminal damaging. This is the defendant kicking the defendant's door, broke the frame, was out of frustration, not an attempt to enter his apartment. But she did try to enter his apartment on another day here. That's the attempted trespass and habitation on the indictment. In speaking with the defendant is 24 years old. She has 1 prior misdemeanor disorderly conduct reduction in the municipal court, which was from June of this year, that also involved Mr. Moss. Other than that, she has no record. Mr. Moss was not scared of the defendant. He has no objection to her bond being reduced even to a known recognizance. He doesn't even think GPS is appropriate. He doesn't want her to come by his apartment anymore.
So why are we here right now for
Because it was a $50,000 cash surety bond, and I didn't feel that it was appropriate for us to just unilaterally change it and present you with a form to that effect, Your Honor. I wanted,
That's a first.
if I was the judge, that's what I'd want. So that's why. So we have an agreement here in terms of the state would not object to an own recognizance bond in this matter with the conditions of no contact
With Bishop Park Apartments or the defendant,
Or
or the
Moss.
victim.
But Mr. Moss did say that he does want to be able to communicate over the phone about the child.
Well,
But I told him
that's going to be too much of a. That's going to have to wait until this gets resolved.
Yes, Your Honor. So
I'm assuming you're good with that bond?
Yes, we have no objection to the owner recognizance bond or the no contact order.
Okay. Well, I'm going to set bond then, reset bond at the defendant's own recognizance with the condition that you have no contact with Bishop Park Apartments and no contact with Mr. Moss. And that means you can't contact him about your child either. And I know that may be an issue now, but I can't say except for these circumstances, because then it can never be monitored or policed. So while this is pending, that's going to have to be the rule. You understand that?
Yes.
And we've reduced your bond substantially, but if you violate that, I'm not going to hesitate to revoke it. If we find out that you reached out to him, and even if you come up and say, well, I found out something about my daughter and I had to talk to him, that's not going to be an excuse. So there's no excuses here. You understand that?
Yes.
All right. And then bond will be reset at defendant's owner cognizance with the condition of no contact at Bishop Park Apartments and no contact with the victim, Mr. Moss. She fill out paperwork? You got one filled out there for
We
her?
have conditions of bond, we do not have the owner cognizance paperwork.
I have OR paperwork, Your Honor. I will give that to Ms. Smith right now.
Smith, you said you had conditions of bond form filled out already?
I do as well later.
What county is Bedford? Is that Cuyahoga County?
That is.
I'm gonna put that up here too then. That's where you're gonna be residing in Bedford?
Yeah.
So this OR bond, Ms. Gray, means you have to show up at all future court dates. And if you fail to appear at a future court date, that's a separate felony that you can be prosecuted for. It's actually more serious than anything you're charged with here right now. And you can get up to 18 months in prison on that, which could be consecutive to anything that could happen with any of these charges. So it's obviously, or at least a felony. So it's obviously important you show up at all your future court dates. You understand that?
Yeah.
All right. All right. Very good. All right. Last case for now, State of Ohio versus Lavelle Vinson, 25 CR 1312. Ms. Smith?
Your Honor, on behalf of Mr. Vinson, he is in receipt of his indictment and has been for more than 24 hours, waives any defects in time, manner, place, or service, waives reading of the indictment as well as advisement as to penalties, respectfully enters a plea of not guilty and asks to be acquitted on bond.
All right. Mr. Vinson, you received a copy of your indictment?
Yes, sir.
When did you get that, sir?
Today.
Okay. So they attempted to serve it, I think, earlier, last week maybe? And then you got a notice and you came in today?
Yes, the address that y'all had on file for me was 2 years old, so I didn't get the original copy.
How did you know that this was scheduled for today?
Well, I had corresponded with my public
right.
defender.
But you received a copy of the indictment?
Yes, sir.
I could read it to you if you'd like, or you can waive the reading. What would you prefer at this time?
You can waive it, sir.
Very well, then, and you're charged with the one count of failure to comply with an order signaled a police officer, felony in the third degree. What is your plea to that count at this time?
Not guilty.
All right, I will enter a plea of not guilty to the charge. Let me start with the state on the matter of bond. Let's cut.
Thank you, Your Honor. Just to clarify, originally, this wasn't set for arraignment today. It was set for October 31st. He was attempted to be served on October 21st. Came back bad address. He did not appear on October 31st for the arraignment. I was contacted last Friday that he wanted to turn himself in on it. I called Ms. Smith back to ask a couple questions. I didn't hear back. The information I have is that it was a bad address. That is the address that is on the clerk's website, and my understanding that he has been using. In addition, part of the bond conditions, the bond at a Willoughby Municipal Court was $25,000 cash surety or 10% with no driving. Initially, it had GPS on it. GPS was then stated to be removed for Lake County because he was on GPS in Cuyahoga County. But the order was that if Cuyahoga County removed their GPS, defendant had to go to the Lake County Probation Department within 24 hours to have GPS put on for this case. I contacted Chief Probation Officer Craig Berry to find out if he was aware of GPS. Initially, he said no, that he didn't believe he was on GPS. He followed up and learned that Cuyahoga County had removed the GPS, and that though the defendant did not go to Lake County Probation Department and have it put on, he did have it put on by On Track. Just Lake County Probation had no idea. So he is on probation in 2 different cases in Cuyahoga County. The reason the GPS was put on in September of 2025 was for a probation violation for failing to report. In addition, just looking at the factors, when we look at bail for the seriousness, for this case, there were multiple traffic violations, including speeds over 120 miles per hour during this failure to comply. Around 3:30 in the morning, there were other vehicles as well as semi-truck on the road. Defendant does have a criminal history. He went to DYS as a juvenile for an assault in 2003 as an adult. In 2009, he has 3 different cases with convictions: felony DV, attempted robbery F3, domestic violence F4, a burglary F2, and another DV F4. The first domestic violence, he had probation and then had a violation. He did have
No, we're not here for sentencing right now.
Right, but part of the factors they do talk about the prior criminal history. So I did want the court to know he has additional felonies in 2015 that he went to prison. In 2017, he has misdemeanors. And then he's on probation for a 2022 case in trafficking and drugs and a 2023 case for domestic violence. There is on his leads a reference to a failure to appear warrant in 2020. He's not able to determine where that came from, and then he didn't show for his arraignment and obviously the failure to report. So we did ask for an increase in his bond to $50,000 cash surety or 10% with conditions of no driving and GPS.
All right. Smith?
Thank you, Your Honor. On behalf of Mr. Vinson, Mr. Vinson posted a $25,000 10% bond out of Willoughby Municipal Court back in September on this matter. He has been out on bond without further issue. He's had no further violations of his probation. He is on supervision to Cuyahoga County and reporting regularly. Additionally, Your Honor, Mr. Vinson did not fail to appear before this court for his arraignment when it was first set out of in a deliberate or willful manner. That was simply because he had not received service.
Why didn't you receive service?
Because it was sent to a bad address.
It was sent to the address that he used off the municipal court. I mean, we didn't just come up with this address. We got it from him. I mean, that's in all the paperwork that he filed, that he signed. That address is there. So,
It's the address that's on his driver's license.
where did you think stuff would get sent it then? I mean, we're supposed to know where you're really living?
No,
The court pre-populated the information.
All right. Where's this? He didn't give another address. He didn't provide an address. How is he supposed to be notified?
I say something.
I don't know who wants to talk, but
Mr. Vinson reached out to counsel as soon as he learned of the warrant and indictment, and counsel reached
I
out.
get it. But he signed the paperwork saying this was his address. Now, maybe it was pre-populated at the Willoughby Municipal Court, but he represented by signing it that was his address. He could have crossed that out and said, "That's not where I live. You're not going to be able to get a hold of me if you try to reach me at this address."
So at that time, I probably didn't look over the paperwork proper, but like since then, I've been on GPS for you guys. So it wasn't like I tried to run from the course or nothing.
I understand that, but we need to have an address of where you're living, and you didn't provide that.
And Mr. Vinson has completed a conditions of bond form
Today,
with a current address. Additionally, he turned himself in upon learning of the warrant, and after counsel spoke with the state. Your Honor, we would ask that his original bond be continued at $25,000, 10%. We don't object to the GPS if the court feels that it's warranted to protect the public safety. However, it does create a financial burden for Mr. Vinson, and if the court is satisfied with his lack of violations since September, we would ask that it be removed.
All right, Mr. Vinson, if you're given a bond, you have to keep the court updated as to where you're living. And you could change. I'm not saying you can't change it, but as soon as it changes, you need to notify your lawyer, and so the courts can be notified, because we have to notify you by sending stuff to the address that you provide for us.
Yes, sir.
We're not mind readers. We don't know, that you don't live at the address that's on there. And I'm not saying it's unusual that someone's address on their license, they live somewhere different from that. Obviously, that happens. But you need to keep us updated. If you move, 1 month and then you move somewhere else you're living, you need to let us know that. And if you don't, it's going to be a violation of your bond. You understand that?
Yes, sir.
All right. Court's got to reset bond at $25,000 cash surety or 10%. Anything else for the record?
Not at this time, Your Honor.
Ms. Cutts?
Your Honor, we'd ask at least for the no driving as a condition.
Yeah, you're not to drive. You're not to drive. The condition of your bond as well. I didn't hear that. If you said that, I missed that. Sorry.
It was no driving and GPS.
Well, I'm eliminating the GPS requirement, but I'm keeping the no driving condition. At least in Lake County. I don't know if there's GPS somewhere else. I have no authority to do anything about that. And do we have a conditions form?
Conditions and speedy trial.
All right, here, Stan, you can put that with that. All right, anything else, Ms. Cutts?
Not this time.
Ms. Smith?
Oh, not this time.
Oh, you answered. All
I
right.
answered.
All right, thank you.
All rise.
Be safe, be well, sleep sweet, and much love.